Hello everyone, I'm Justice and welcome to Justicia Serie. So for this video, we will talk about Rule 115 of the Rules of Court entitled Rights of the Accused. So let's begin. So as an overview, we have 9 rights of the accused, and basically these rights have constitutional origin. So galing ito sa Constitution ng Pilipinas, and they are simply reiterated in the rules of court under Rule 115. So let's start with the first right, to be presumed innocent until the contrary is proved beyond reasonable doubt. The second one is to be informed of the nature and cause of the accusation against him, to be present and defend in person by counsel at every stage of the proceedings, from arraignment to promulgation of the judgment, to testify as a witness in his own behalf, but subject to cross-examination on matters covered by direct examination. His silence shall not in any manner prejudice him. To be exempt from being compelled to be a witness against himself. To confront and cross-examine the witnesses against him at the trial. To have compulsory process issued to secure the attendance of witnesses and production of other evidence in his behalf. To have speedy, impartial, and public trial, and to appeal in all cases allowed and in the manner prescribed by law. So let's start with the presumption of innocence. So under the rules, in all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved. As a consequence of this presumption, the burden now lies with the prosecution to prove that the accused is not innocent. So unless the prosecution successfully discharge their function of proving the guilt of the accused, then the accused will remain innocent of the case, and therefore his case, or he will be acquitted from the case. So what is the burden of proof in proving the guilt of an accused in criminal cases? Under the rules of court, the burden of proof required to prove the guilt of the accused in a criminal case is proof beyond reasonable doubt. So what is this proof beyond reasonable doubt? The rule says that proof beyond reasonable doubt does not mean such a degree of proof as excluding possibility of error produces absolute certainty. Moral certainty only is required, or that degree of proof which produces conviction in an unprejudiced mind. So this explains why circumstantial evidence is allowed in proving the guilt of an accused in a criminal case. Otherwise, if what is required is absolute certainty, then the evidence should be direct, or there should be, for example, in a murder case, an eyewitness who saw the murderer, who has a personal knowledge of the facts constituting the offense. And circumstantial evidence will not be entertained in the criminal prosecution. This means, this burden of proof means that the presentation of evidence, or in proving the guilt of the accused, there could be errors. However, as between the slight error, the error and the evidence presented by the prosecution, if despite error, it can be proven, with moral certainty, or the moral conscience of a person would tend to be inclined to believe that the accused had really committed a crime. So, in short, when you say proof beyond reasonable doubt, it doesn't require that the evidence is perfect. There is no error. So, hindi ganun ang proof beyond reasonable doubt. What is merely required is moral certainty that based on our conscience, based on the evidence presented, it can be concluded that the crime has been committed and the person being charged in the criminal case is the one who committed it. Okay? So that is proof beyond reasonable doubt, or that quantum of proof sufficient to produce a moral certainty that would convince and satisfy the conscience of those who act in judgment. So take note that the law enforcers who enforce the law enjoy presumption of regularity in the performance of their public function. So, can that presumption overstep the presumption of innocence of the accused? The Supreme Court held in several cases that while public officers or law enforcers enjoy the presumption of regularity in the performance of their official functions, if there are evidence that would prove that the police officers or the law enforcers had performed their functions with irregularities, or that their functions are tainted with irregularities, then that presumption is rebutted, and therefore the judgment should be uh, made in favor of the accused, because the presumption of innocence is not overcome by the prosecution because of the irregularity committed by the police officers or the law enforcers. So therefore, the prosecution should take note that in order to make use of the presumption of regularity, there should be no irregularity committed by the law enforcers. Now, under this presumption of innocence, we also have this principle of equipoise rule, which means that where the evidence is evenly balanced, the constitutional presumption of innocence tilts the scales in favor of the accused. So that is held by the Supreme Court in the case of People versus Ergiza, GR number 171348, November 26, 2008. So let me give you a brief discussion of this case, no, of People versus Ergiza. Actually, this case is a rape case, no, of a minor child who is a high school student, and she was alleged to have been raped by the accused here with the surname Ergiza. Hence, the title of the case, People versus Ergiza. Now, actually, the equipoise rule here was applied because the testimony of the complainant, the rape victim, is inconsistent, or is not did not jive, no, with the testimony of the witness of the defense. So the particular testimony goes like this. The complainant said that on the day of the commission of the crime, the complainant and her best friend, together with her best friend's brother, went to a mango orchard. And she alleged that her skirt was stuck in a fence. And therefore, while she was retrieving her skirt, her best friend and her brother's best friend left her in the field, in the mango field or mango area. Okay. Now, at the time, the accused, Ergiza, approached the victim. That was her allegation. And that the accused took the victim and raped her at that time. That was around 5 p.m., no? 5 p.m. on the day of the commission of the crime. Now, the best friend of the complainant was presented as the witness of the defense. She stated, or she alleged in her testimony, that when the skirt of the complainant was stuck or on the fence, she never left the complainant during the entire time until they went home and separated at the house of Aunt Betty. Okay? So she said that she didn't leave the complainant during the entire time, and that she did not accompany her brother together with them in the mango field. So, in analyzing the conflicting testimonies of the complainant and the defense witness, the Supreme Court said that the defense witness could be lying, or the complainant is the one who is lying. So, it's either si defense witness yung nagsisinungaling or yung complainant. And take note that in rape cases, the court usually give credence to the testimony of the rape victim, considering the nature of the crime. That usually rape cases are usually done in secret, and therefore it would be the least possibility is to have an eyewitness. So it is least probable, no, na merong eyewitness in a rape incident. And so most of the courts will give weight or credence to the testimony of the complainant or the rape victim. But here in this case, the testimony of the rape victim here was contradicted by the testimony of her best friend. And so the Supreme Court said that since they could not determine which of the two is telling the truth, the evidence is therefore evenly balanced. And since it is balanced, or the testimony is capable of two interpretations, one in favor of the accused and the other in favor of the complainant, then the burden of proof is not was not successfully discharged by the prosecution. And therefore, the accused is, and therefore the constitutional presumption of innocence of the accused was not overcome, and the accused should be acquitted as a matter of course. Okay, so that was the ruling of the Supreme Court in the case of People versus Ergiza. Before we go to the next right, let me just emphasize that in proving the guilt of the accused, the prosecution must rest on its own merits to prove the guilt of the accused rather than on the weakness of the defense. Okay? So even if, for example, the accused does not have an evidence to prove his claim that he did not commit the crime. Okay, let me just phrase that this way. Let us say, for example, the prosecution has no enough evidence or sufficient evidence to prove the guilt of the accused. Meaning to say, the prosecution was not able to successfully discharge the burden of proof, which is proof beyond reasonable doubt. And now here comes the evidence of the accused, which is also weak. So, ano ba ang dapat na desisyon ng korte kung ganyan ang sitwasyon? Under the rules, since the rule says that the prosecution must rest on its own merits and or must stand on the strength of of its evidence, not on the weakness of the defense. Then, if both sides have weak defense or have weak evidence, then the presumption of innocence will be upheld, and therefore the accused should be acquitted. Okay? Now let's proceed to right to be informed of the nature and cause of accusation. Here, you should take note of the contents of the complaint or information, because the right of the accused to be informed of the nature and cause of accusation against him can be exercised by examining the facts or matters stated in the complaint or information. If you can recall, Rule 1110 of the, or Rule 110 of the Rules of Court, that rule provides for the requirements or the matters that should be stated in the complaint or information so as to make the complaint or information sufficient for the filing of a criminal case. So remember, the matters that are required to be stated in the complaint or information. Number one is state the name and surname of the accused or any appellation or nickname by which he has been or is known, and if his name cannot be ascertained, to describe him under a fictitious name. Second, aside from the accused, then you should also state the name and surname of the offended party. Or if his name or surname cannot be ascertained, his nickname or appellation. And if there's no way of identifying him, even his nickname or appellation, then describe him under a fictitious name. If the offended party is a juridical person, it is sufficient to state its name or any name or designation by which it is known or by which it may be identified. Next, to state with sufficient clarity and in ordinary and concise language the acts or omission constituting the offense to enable the accused to know the offense he is being charged with. So aside from stating what offense the accused has allegedly committed, we should also state in such particularity, in ordinary and concise language, the acts or omissions constituting the offense charged, in order for the accused to know ano yung mga acts complained of and to prepare for his defense. To state the designation of the offense given by statute unless there is no such designation, in which case it is sufficient to make reference to the section or subsection of the statute punishing the offense. To state also in ordinary and concise language the qualifying and aggravating circumstances attending the acts imputed to the accused. To sufficiently allege that the crime was committed or its essential ingredients occurred at some place within the jurisdiction of the court. To allege the date of the commission of the acts or omissions constituting the offense, which date may be one as near as possible to the actual date of commission of the offense, except when the precise date is a material ingredient of the offense. So if you can recall these provisions, in offenses against property, if the name of the offended party is unknown, the property must be described with such particularity to properly identify the offense charged. So in implementing the right of the accused to be informed of the nature and cause of accusation against him, the rules of court specifically require that the acts or omission complained of as constituting the offense, including the qualifying and aggravating circumstances, must be stated in ordinary and concise language, not necessarily the language used in the statute, but in terms sufficient to enable a person of common understanding to know what offense is being charged and the attendant qualifying and aggravating circumstances present, so that the accused can properly defend himself and the court can pronounce judgment. So that is why if the prosecution failed to state the qualifying and aggravating circumstances of the crime so as to change or to to make the crime a grave offense, then you cannot, or the prosecution cannot convict or cannot prove the guilt of the accused with such or the guilt of the accused on the crime with qualifying or aggravating circumstance. So it is required or it is necessary for the prosecution to state in ordinary and concise language, although the rules does not require that it should be in the same words as used no, in the statute, for as long as it can be understood to mean that 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 particular statement refers to the qualifying or aggravating circumstance referred to by the statute. So, if for example the statements or the allegations in the complaint or information merely supports the filing of a simple rape, or let us say a homicide case, then the accused cannot be convicted of a crime of murder in the absence of the allegation of any qualifying circumstance that would aggravate the crime to murder. So even if the crime of murder necessarily includes the crime of homicide. So that is the determining point, whether or not the prosecution have sufficiently alleged the qualifying or aggravating circumstance. Otherwise, you cannot aggravate the offense because it would be in violation of the accused's right to be informed of the nature and cause of accusation against him. So, if a particular element is material to prove an offense, all the elements, all the facts that would constitute the elements of the offense should be stated in the complaint or information. Otherwise, you cannot convict the accused of the crime charge, no? If the elements are not proven beyond reasonable doubt. So in one case also, the Supreme Court acquitted the accused for there was a discrepancy between the identity of the check in the complaint or information and that the check the check that was exhibited in the case. So let us say, for example, the check number that was alleged or stated in the complaint or information bears the serial number 12345, and what was exhibited in the case was check number 12346. So, since there was a discrepancy between the identity of the check in the complaint or information and in the records of the case, then there is a violation of the right of the accused to be informed of the nature and cause of accusation against him. So, as a result, the accused can be acquitted in violation of this right. So, right to counsel of the accused at all times. Okay? So, I have put here questions, no? And we will answer these questions one by one. So, first is, when can a person invoke his or her right to counsel? So, under the rules, there are 3 instances where a person can invoke his right to counsel. Number 1 is if a person is arrested. When he is arrested of a crime, for the commission of a crime, okay? So he can invoke his or her right to counsel. Second one is when the person is detained. Okay? If he is detained, then he can invoke his or her right to counsel. Another is if the person was under custodial investigation. So he can also invoke his or her right to counsel. Okay? Again, this right to counsel um, has a constitutional origin, no? Part of the fundamental principle of due process, okay? So, if a person is not afforded his right to counsel, then there is a violation of his constitutional right. And therefore, any acts or any testimonies elicited from him in violation of this right may be inadmissible as evidence in court. Okay, what is, we mentioned earlier about custodial investigation. So what is this custodial investigation? It means that any questioning initiated by law enforcement authorities after a person is taken into custody or otherwise deprived of his freedom of action in any significant manner. So when you say custodial investigation, the police officers are trying to ask questions, and they intend to elicit testimonies from the accused. And take note here that the person must have already been taken into custody or otherwise deprived of his freedom of action in any significant manner. Otherwise, any questioning that is done by the police officers or law enforcers cannot be considered as a custodial investigation. So hindi pa siya magiging custodial investigation if the person being asked is not yet treated as a suspect. Okay? So, saka siya magiging custodial investigation if the accused or the not necessarily the accused or the person being asked is already suspected, no, to have committed the crime that they are the crime that is subject of the investigation. Now, let us go to some cases, no, wherein you can invoke, no, your right to counsel. Let us see, for example, in a police lineup, for example. So you were invited, or a person is invited in the police station uh, to ask him for any matters relating to a crime. So now the question here is whether or not police lineup uh, is part of the custodial investigation so that the accused can invoke his or her right to counsel. Now, the Supreme Court held, no, in several cases that a police lineup is not equivalent to a custodial investigation because in a police lineup, it was an investigatory activity, no, by the law enforcers. Meaning to say, they are still looking for the accused or the culprit, no? Hinanap pa nila kung sino yung merong motive, kung sino yung talagang nag-commit ng crime or suspect, magiging suspect nila. So, when you say police lineup, there are many persons, no, many persons who are invited, no, to come in a police lineup. So, lineup, maglinya na sila, and then ang ginagawa dyan is the eyewitness, for example, will identify which among the persons invited is or who among the persons invited is the one who committed the crime. So, i-identify yan ng eyewitness, sino sa kanila. So, that is police lineup. Now, if you are now arrested and questions are being asked of you, then custodial investigation begins to custodial investigation is already starting. So therefore, the accused can now invoke his or her right to counsel. Kaya nagsugod naman ang custodial investigation. Why? Because the investigation now has narrowed down to you as a suspect. ikaw na ngayon ang suspect nila. And therefore, since you are now the suspect, questions may be incriminating in nature because gusto na nilang kunin yung testimony na ikaw talaga yung nag-commit ng crime. So this time, you can now invoke your right to counsel because the investigation is no longer investigatory in nature but accusatory in nature. Accusatory na siya kasi ikaw na ngayon ang suspect of the crime. Take note that when you say custodial investigation, it doesn't mean that you are already arrested by the law enforcers. It could also mean that you were invited by the law enforcers for questioning, and the questioning is somewhat accusatory in nature, meaning to say parang they are suspecting you to have committed a crime. So therefore, at that point in time, you can now invoke your right to counsel. Okay, so you may not answer the question if without the assistance of your counsel. So you can refuse to answer the question. So what is the basis of this right to counsel? Again, this is based from the constitutional provision, no? This has a constitutional origin, no? Basic fundamental right of the accused in a criminal case. So when can the right to counsel attaches? So it will attach, no, if the questions are incriminating in nature. Or if, for example, you are already suspected of the crime, di ba? So, nag-a-attach na yung right to counsel. And even if you are not yet arrested, you have the right to counsel. Kunyari, the police officers will arrest you. So, before arresting you, you can call your counsel. And when you are detained, if you are being asked of any questions related to the crime you are suspected of, then you can invoke your right to counsel. And also, if you are under custodial investigation. So, what about in administrative cases? Do we have similar right in administrative cases? Same ba yan yung right to counsel in criminal case and in administrative cases? Okay, the answer is no. Under the law, there is no such requirement in administrative proceedings that the person charged of the administrative offense has the right to counsel. So we do not have a similar rule on this right in administrative proceedings. So the person here, subject of the administrative case, may or may not be assisted by counsel. And take note that the rules of court may not be strictly applied in administrative cases, and therefore yung right to counsel then will not also be strictly applied in administrative cases. So take note that if a person is uncounseled, meaning to say wala siyang lawyer, the court should ask the person or the accused if he wants to hire a counsel of his own choice. But if he does not want to hire a counsel of his own choice, then the court must ask him or must insist on providing him a counsel. If this is very important, if the accused cannot or has no capacity of defending himself. So wala siyang capacity to defend himself, He does not have the requisite knowledge, or expertise to defend himself. But there are cases that the accused may defend himself without the assistance of counsel. And the court should make sure that it was intelligently made, that the accused intends or voluntarily waive his right, to counsel. Okay? And take note that in giving the accused a counsel de officio, or in appointing a counsel de officio, the accused should appoint a competent and an independent counsel. Otherwise, even if the even if the court had appointed a counsel de officio, and if that counsel de officio is incompetent and with a questioned independence, or questioned parang ano siya, he is not independent, para mas madali, then there is still a denial of the right to counsel. So violation pa din siya ng right to counsel kahit na the court assigned a counsel de officio. So again, in assigning a counsel de officio, the court should assign a competent and independent counsel. So take note that under the law, rights may be waived. So, however, in criminal cases, in order to validly waive a right, example, the right to counsel, there are requirements under the rules. Otherwise, there is no valid waiver, and therefore, the right of the accused to counsel is deemed violated. So what are the requirements in order to validly waive the accused's right to counsel? Number one, the waiver must be voluntary and intelligent. So the accused must have decided voluntarily and intelligently that he does not need a lawyer. Second one, that it should be in writing. And third one, that it must be done in the presence of the counsel of the accused. And we have already discussed right to counsel in administrative cases. We do not have an equivalent rule in administrative cases. Right to speedy trial. So who can invoke the right to speedy trial under the rules? The right to speedy trial is a right of the accused in a criminal case, and therefore, he is the one who can only invoke this right. So siya lang makaka-invoke ng right to speedy trial. What is the basis of this right? Again, this is a constitutional origin. Under Section 14, Paragraph 2 of Article 3 of the Constitution, which provides that in all criminal prosecutions, the accused shall enjoy the right to have a speedy, impartial, and public trial. Okay? Right of speedy disposition of cases versus right to speedy trial. Take note that these two terms have different meanings. Although they refer to the speedy disposition, they both refer to the to the period of resolving the case, that it should be speedy, that it should not be delayed, arbitrarily or whimsically. So, however, they are different terms because when you say the right to speedy disposition of cases, this can be invoked before any tribunal, whether judicial or quasi-judicial or administrative bodies. But when you say right to speedy trial, this can be invoked only in a criminal proceeding. So right to speedy trial is used in criminal proceedings, while right of speedy disposition of cases can be invoked in any proceedings, no, judicial or quasi-judicial or administrative proceedings. So when can you say that the right to speedy trial is deemed violated? So take note of these three instances, no, wherein the court can declare that this right is violated. Number one, when the proceedings are attended with vexatious, capricious, and oppressive delays. Second one, when unjustified postponements of the trial are asked for and secured. Or when, without cause or justifiable motive, a long period of time is allowed to elapse without the party having his case tried. So when you say right to speedy trial or right of speedy disposition cases, uh, does it mean that the criminal proceedings or the proceedings do not allow postponements of the case? The answer is no. Under the ruling of the Supreme Court in the case of People versus Sandigan Bayan, a mere mathematical reckoning of the time involved is not sufficient. So here, when you say right to speedy trial or right of speedy disposition of cases, it doesn't mean that postponements are not allowed, no, in the disposition of the case or in the trial of the case, because mere mathematical computation uh, is not the basis, no, for determining that there is a violation of the right of the accused to speedy trial. So what should be considered in determining whether or not there is a violation of the right to speedy trial? The rules of court says that uh, the court should take into account the facts and circumstances obtaining in each particular case, because the concept of speedy disposition or speedy trial is relative in nature and therefore flexible. It means that it has no uniform standard, it has no fixed rule. So it depends upon the facts and circumstances of each case. So what is the inordinate delay in one case may not be true in the other case. So that is what is meant by the Supreme Court in its decision in People versus Sandigan Bayan. Because the right to speedy trial is violated only when the proceedings are attended by vexatious, capricious, and oppressive delays, when unjustified postponements of the trial are asked for and secured, or when without cause or justifiable motive, a long period of time is allowed to elapse without the party having his case tried. So meaning to say, there is a considerable allowance for delays and postponement, no, in the trial of the case. But the court should make sure that the delays and postponements should not be vexatious, capricious, and oppressive. It should not be unjustified, or these extensions of time should be with just cause or just motive. So let us examine, let us have an examples, no, kung when kung a particular excuse ba is valid or justified in order to extend or in order to postpone or incur delays in the proceedings of the case. Number one is a judge illness. The reason for the delay is because the judge is ill. Is that a just or a valid cause in order to prolong the disposition of the case? The answer is no. The Supreme Court said that the demands of public service cannot abide by his illness. And if the judge is of poor health, he should ask from the Supreme Court for an extension of time to decide cases. So another example is um, the designation of a judge to preside over another sala, meaning to say the judge is holding more than one sala. So that is not a valid reason to delay or to justify the delay in deciding a case. Heavy workload is also not a valid reason. Delays caused by poor health, old age, heavy caseload, among others, do not totally absolve a judge but only serve to mitigate the penalty from liability. Absence of a branch clerk of court should not affect the prompt disposition of cases because it is the duty of the judge to recommend someone, no, for immediate appointment. No? If, for example, uh, there was a resignation or absence of a branch clerk of court. The non-submission of the transcript of stenographic notes by stenographers. So this will not relieve, no, the judge from rendering a decision in the case. Okay. So when you say right to speedy disposition of cases, again, this is available in all judicial, quasi-judicial, or administrative bodies. Unlike right to speedy trial, which is available only in criminal cases. Now, let us talk about doctrine of inordinate delay. Dismissal based on a violation of the right to speedy disposition of cases. So, an example of inordinate delay is the case of Coscolluela versus Sandigan Bayan, First Division 701 SCRA 188, July 15, 2013. So the case stemmed from a letter complaint received on November 9, 2001 by the Office of the Ombudsman for the Visayas from a private organization requesting for assistance to investigate the anomalous purchase of medical and agricultural equipment in the amount of 20 million pesos, which allegedly happened around a month before the petitioner, former governor of his province, stepped down from office. So remember, uh, the letter complaint was received by the Office of the Ombudsman on November 9, 2001. The case was assigned to the investigation officer and the investigation officer prepared a resolution finding probable cause on March 27, 2003. So that means more than 1 year after the filing of the letter complaint. On the same date, the information was prepared and signed, and then the corresponding recommendation for its approval was made. However, the final approval of the acting ombudsman came only on May 21, 2009, and finally on June 19, 2009, the information was filed with the Sandigan Bayan. So, meaning from November 9, 2001 to June 19, 2009, so there was a period of more than 7 years or more than 7 years no before the information was filed with the Sandigan Bayan. Now the issue here is whether or not there is a violation of the accused right to speedy trial because this is a criminal case, no? Ano ang ruling ng Supreme Court? resolved the issue in the petitioner's favor, meaning to say, in the accused favor, and ordered the Sandigan Bayan to dismiss the case for violation of the petitioner's constitutional right to speedy disposition of cases. Ang ginamit nila dito ay speedy disposition of cases because this is a case before the ombudsman. So the Supreme Court held here that the preliminary investigation proceedings took a protracted amount of time to complete because the proceedings were terminated only on May 21, 2009, or almost 8 years after the filing of the complaint. Okay. So the court here did not agree with the Sandigan Bayan that the delay in proceedings could be excused by the fact that the case had to undergo careful review and revision through the different levels in the office of the ombudsman before it is finally approved, in addition to the steady stream of cases which it had to resolve. So the Sandigan Bayan also raised here that the respondent should have followed up their case without waiting for the decision of the Sandigan Bayan. But the Supreme Court here said that the defendant has no duty to bring himself to trial, and therefore he has no duty to follow up his case. So here the Supreme Court said that there was an inordinate delay in the resolution of the preliminary investigation proceedings. And therefore, since there was an inordinate delay, the accused's right to speedy disposition of cases is therefore violated. There is also one issue regarding investigations conducted by the Office of the Ombudsman that involves the fact-finding investigations of the Ombudsman. The question is whether or not the right of the accused to speedy trial is applicable in fact-finding investigations conducted by the Office of the Ombudsman. The Supreme Court ruled in the case of Kagang versus Sandigan Bayan, GR numbers 206438 and 206458, decided on July 31, 2018, which effectively abandoned its earlier rulings about fact-finding investigations conducted by the Office of the Ombudsman. The Supreme Court held here that fact-finding or the right of the accused to speedy trial do not apply in fact-finding investigations because according to the Supreme Court, fact-finding investigations are not yet adversarial proceedings against the accused. So the period of investigation will not be counted in the determination of whether the right to speedy disposition of cases was violated. Thus, the court holds in this case that for the purpose of determining whether inordinate delay exists, a case is deemed to have commenced from the filing of the formal complaint and the subsequent conduct of preliminary investigation. So the ruling that the fact-finding investigations are included in the period of determination of inordinate delay is deemed abandoned. So the right to speedy trial will start to operate from the filing of the complaint up to the trial of the case. Okay, so that is that is when you can invoke the accused's right to speedy trial. Now, there are approaches used by the court in deciding or in determining whether there is a violation of the right to speedy trial. And these approaches are the following. Number one is fixed time period, which holds the view that the Constitution requires a criminal defendant to be offered a trial within a specified period of time. Meaning to say, here in fixed time period, you are counting the number of days. So if the accused, there is a lapse in these periods prescribed by the law or by the rules, then automatically there is a violation of the right to speedy trial. Second one is demand waiver rule, which provides that a defendant waives any consideration of his right to speedy trial for any period prior to which he has not demanded. So, in short, ang ibig sabihin ng demand waiver rule is that if the accused will not invoke his right or will not assert his right to speedy trial, irrespective of the period of time, then the right to speedy trial is deemed waived. Now, take note that the Supreme Court rejected both fixed time period approach and demand waiver rule because of the strict or stringent application. Remember that when you say the concept, no, yung concept ng right to speedy trial or right to speedy disposition of cases is flexible or relative in nature, and it depends upon the facts and circumstances of each case, and therefore you cannot strictly or strictly apply or strictly use the fixed time period kasi relative siya and flexible depende sa circumstances of the case. And also the demand waiver rule kasi masyadong strict yung itong dalawang approaches, and so the Supreme Court rejected both of these approaches. And they currently use the last approach, which is the balancing test, no, in determining whether or not there is a violation of the right to speedy trial. So in balancing test approach, the conduct of both the prosecution and defendant are weighed. So, tinitimbang ngayon kung ang conduct ng prosecution tsaka ng defendant. Taking into account, number one, the length of delay, the reason for the delay, defendant's assertion of his right, and prejudice to the defendant. So, first, yung length of delay. Usually, this is the, according to the Supreme Court, no, to some extent, a triggering mechanism. So, like for example, it took the prosecution to file an information for a period of 10 years, no, from the filing. So, yung length ng delay could be a triggering mechanism that could make the court conclude that there is really a violation of the right of the accused to speedy trial. However, again, you should or the court should take into account the circumstances no obtaining in each case, no, depende. And depende din sa crime committed. For example, a light offense, delay in the proceedings or in the filing of the information for light offenses can be tolerated than the delay committed in the filing of a grave offense or a more serious offense. So parang you just weigh no the length based on the circumstances no of each case. So you cannot say that the 10-year period in this case is also the same in the 10-year period in another case. So depende talaga sa facts and circumstances of the case. Second is the reason for the delay. So we have already mentioned no kung ano yung mga unjustified reasons. So that na hindi pwedeng i-consider no in allowing the delay, okay? And there are also reasons that are valid no and justified. Example, a missing witness, for example. So it would be difficult for the prosecution to proceed without the material witness. And that is one of the valid reasons no, for the delay. Defendant's assertion of his right. So here actually, the Supreme Court said that whether and how a defendant assert his right is closely related to the other factors mentioned. No? The strength of his efforts will be affected by the length of the delay, to some extent by the reason of the delay, and most particularly by the personal prejudice, which is not always readily identifiable. So the more serious the deprivation, the more likely a defendant is to complain. The defendant's assertion of his speedy trial right then is entitled to strong evidentiary weight in determining whether the defendant is deprived of the right. So the court emphasized that failure to assert the right will make it difficult for a defendant to prove that he was denied a speedy trial. So actually, there is really no strict requirement that the defendant should invoke his right, okay, to speedy trial. Because sabi natin kanina, if the length of the delay will prove that there is a denial, taking into account the peculiar circumstances of each case, will prove that there is really a deprivation of the right to speedy trial, then the court can decide that there is indeed a violation of such right. But sabi ng court, if the defendant will assert his right, then that is a strong evidentiary that is entitled to strong evidentiary weight. So meaning to say, if the defendant will assert his right, there is really a deprivation of such right. Otherwise, he will not assert his right, sabi ng Supreme Court. So kapag nag-assert na ngayon sa defendant na kanyang right, meaning to say, he felt violated, he felt denied or deprived of his right. So therefore, it will be accorded a great weight by the court in determining if there is indeed a violation of the right to speedy trial. Okay? And prejudice to the defendant. According to the Supreme Court, prejudice should be assessed in the light of the interests of defendants, which the speedy trial right was designated to protect. So, the court identified three interests: to prevent oppressive pre-trial incarceration, to minimize anxiety and concern of the accused, and to limit the possibility that the defense will be impaired. So for example, an example of prejudice to the defendant is when the defendant loses his material witness because of the inordinate delay in the proceedings. So it could affect the defense now of the accused, or it could affect his theory of the case, and therefore prejudicial to his case, di ba? So another example is if the case will be delayed for a long period of time, the witness may be unable to recall accurately the events reflected in the record. So the defense witness may forget or may not recall everything that has happened. So therefore, it is prejudicial to the interest of the defendant or prejudicial to the defense. Okay? So take note of the time limits under Section 8 of AM 12-11-2. So, raffle of cases, it should be taken within 3 days from the filing of the information. Arraignment, 10 days from the date of raffle. Pre-trial conference, 30 days from arraignment, or 10 days if the accused is under preventive detention. Then trial, 30 days from the termination of the pre-trial conference. If the case will undergo a regular trial, meaning to say the witness will take the witness stand in court, then the trial will be done within 180 days from the date the trial begins. But if the trial is by affidavits, then 60 days from the date the trial begins. And take note that both Regular trial and trial by affidavits are subject to the excluded delays or postponements under Rule 119 of the Rules of Court and the Speedy Trial Act of 1998. So an example of excluded delays, no? Allowable delays in computing the period for commencement of trial is delay resulting from an examination of the physical and mental condition of the accused. For example, in a drugs case, if the accused will plead guilty to a lesser offense and the accused wanted to apply for probation, there is this drug dependency examination that is being conducted on the accused. So that could justify the delay, no? That the accused will still undergo drug dependency examination before the resolution of the probation application. So that is that delay or postponement is excluded in the computation, no, of the period of trial. Another example is delay resulting from extraordinary remedies against interlocutory orders or delay resulting from a finding of the existence of a prejudicial question, because diba, in a prejudicial question, the party invoking that may move for the suspension of the criminal proceedings, and therefore the postponement or the suspension or the period of suspension is excluded in the computation of for the period of trial. Okay. Factors for granting continuance, meaning to say the court may grant an extension of time beyond the time allowed by the rules of court on the following grounds, no? Whether the failure to grant such a continuance in the proceeding would likely to make a continuation of such proceeding impossible or a result in miscarriage of justice. And second one, whether the case as a whole is so novel, bago, so unusual and so complex, no, due to the number of accused or the nature of the prosecution or otherwise, that it is unreasonable to expect adequate preparation within the periods of time established by the Speedy Trial Act. So effect of the violation of the right to speedy trial. So the trial court may dismiss the case on a motion nolle prosequi. So Latin, that is Latin for we shall no longer prosecute. So equivalent, and the dismissal here is equivalent to an acquittal, even if the dismissal is with the consent of the accused. So take note that generally dismissals with consent of the accused will not operate to attach the principle of double jeopardy, or double jeopardy will not attach, no, in dismissals with consent of the accused. One of the exceptions to the rule is dismissals on the ground that the right of the accused to speedy trial is violated, even if that dismissal is with the consent of the accused. And since this is equivalent to an acquittal, then double jeopardy attaches. So the accused can no longer be put into trial for the same offense. Now let's proceed to privilege against self-incrimination. So the pertinent provisions for this right are the following. Number one, Section 17, Article 3 of the Philippine Constitution, no person shall be compelled to be a witness against himself. Second one is, in all criminal prosecutions, the accused shall be entitled to the following rights: to be exempt from being compelled to be a witness against himself. Okay? The scope of this privilege against self-incrimination applies only to testimonial compulsion or a compelled testimony of a communicative nature. So what does this mean? If, for example, what is being taken from the accused is not testimony or not anything that has a communicative that is communicative in nature, then this right or this privilege against self-incrimination will not be applied. For example, in purely mechanical acts. So we will discuss later. So right against self-incrimination of an accused is different from that of an ordinary witness. So remember that uh, the accused can refuse not to take the witness stand. And therefore, if the accused refused to take the witness stand, then no cross-examination can be made against him. But if the accused will take the witness stand, he will be cross-examined only on matters covered by the direct examination. So therefore, if the matter is not asked during the direct examination, then the opposing counsel cannot ask questions which are outside the matters covered by the direct. So that is the limitation, no, in cross-examining an accused. On the other hand, if an ordinary witness is put into the witness stand, the opposing counsel can ask as many questions as he wants, provided they are related or they have a relation to the case, no, or to the criminal case. So even if the question is not covered by the direct examination. So that is the difference, no, between right against self-incrimination of the accused and the right against self-incrimination of the witness. So if that is the case, sabi natin, di ba, the accused can refuse to take the witness stand because he can protect himself from self-incrimination. Baka later, sa cross-examination, the opposing counsel will propound questions that could incriminate him. Okay, but he can still refuse to answer questions that could incriminate him, no, by invoking that right if he will take the witness stand. But he can protect himself from self-incrimination if he will refuse to take the witness stand. So kapag ayaw niya talaga, gusto niya talagang i-protect yung sarili niya from any incriminating questions from the prosecution, then he can refuse, no, to take the witness, and he cannot be compelled, no, to take the witness stand. Okay, and on the other hand, in an ordinary witness, the witness cannot refuse to take the witness stand. In fact, the court can issue a subpoena ad testificandum to the witness, to the material witness, compelling him to take the witness stand. So he cannot refuse to take the witness stand. The ordinary witness can only invoke his right against self-incrimination every time a question is propounded against or propounded to him, or every time an incriminating question is being asked. So if the question is not incriminating, then the witness is obliged or compelled to answer the question. But if the question is incriminating, then that's the only time that the witness can invoke his right against self-incrimination. So we mentioned earlier that the scope of the privilege against self-incrimination applies only to testimonial compulsion or a compelled testimony of a communicative nature. Now, what if, for example, the accused was asked to reenact the commission of the offense? So is the reenactment a violation of the privilege against self-incrimination? Okay. The Supreme Court held in People versus Olvis, GR number 71092, September 30, 1987. The forced reenactments are deemed to have been in violation of the right of the accused against self-incrimination. Take note here that when you say reenactment, it means that the accused is being obliged to repeat what has happened in the commission of the crime. So meaning to say, it does not involve, meaning to say, in reenacting the commission of the crime, the accused is deemed to have been giving a testimony. Para siyang testimony of a communicative nature. So while it is the body of the accused that is moving, di ba? In reenactment, you are not testifying, di ba? Like saying anything in reenactment, but you are moving, you are reenacting what has happened, and the Supreme Court said that that is deemed to have been a testimony. Para siyang testimony because it is communicative in nature. It communicates something. It tells us something. So, it is akin to a testimony. So, therefore, the privilege against self-incrimination applies to forced reenactments, and therefore, it is considered a violation of the right of the accused against self-incrimination. So, meaning to say, the privilege against self-incrimination does not apply only to actual testimonies made in court. It will also apply to anything that is communicative in nature, including body movements, no, in forced reenactment. So, kahit na hindi siya by words, since it is communicative in nature, the Supreme Court said that it is a testimony. The accused is giving a testimony by reenacting the commission of the offense, and therefore a violation of his right against self-incrimination. But here in the same case, the Supreme Court distinguished testimonial compulsion or a compelled testimony of a communicative nature and or from mechanical acts. The accused is made to execute not meant to unearth undisclosed facts but to ascertain physical attributes determinable by simple observation. So what are examples of mechanical acts? Like DNA testing. Taking a urine from the accused for urine testing to determine the existence of methamphetamine hydrochloride or shabu in the urine, or if the accused is compelled to undergo a pregnancy test. So the Supreme Court said that these kinds of acts are mechanical acts. No? These are mechanical acts, and therefore they are not considered in violation of the accused right against self-incrimination. Kasi you are not revealing what is not yet disclosed. Kasi nga, kung buntis ka and then you are made to undergo a pregnancy test, hindi naman nire-reveal ng pregnancy test ang something or ang fact na hindi nag-i-exist. Nagre-reveal lang siya of existing facts, which is that you are pregnant. So, kung i-compare mo siya sa first three enactments, in first three enactments, you are revealing something which is not available as of the moment, or you are revealing some evidence which is not yet available in the prosecution. But when you say you will undergo a pregnancy test, kasi you are not unearthing some undisclosed facts because you are just observing physical attributes of the person, okay? So, if he is really pregnant or not. Another is like if you are required to give your give a urine sample for test of the existence of marijuana or shabu, no, as the case may be. So the Supreme Court said that this is purely a mechanical act which does not reveal something that is undisclosed. Okay? So therefore, it does not violate the right of the accused against self-incrimination. What about what if, for example, the accused was compelled uh, to write his signature or to make a signature? Parang the accused will be uh, required to write on a piece of paper in court, no, in open court. So will that violate the right of the accused against self-incrimination? The Supreme Court held in the case of Beltran versus Samson, 53 Phil 570, that writing is something more than moving the body or the hands or the fingers. Writing is not a purely mechanical act because it requires the application of intelligence and attention. And if, for example, the accused is being charged of the crime of falsification of public document, so if he will be required to write something on a piece of paper, and if that writing will be compared now to the falsified document, then the accused could be incriminating himself. And therefore, the Supreme Court said that that is not allowed. That is in violation of his right against self-incrimination. So in this case of Beltran versus Samson, the Supreme Court said that writing means that the petitioner herein is to furnish a means to determine whether or not he is the falsifier, as the petition of the respondent fiscal clearly states. Here, the witness is compelled to write and create by means of the act of writing evidence which does not exist and which may identify him as the falsifier. But take note that not every act of affixing one's signature is within the protection of the privilege against self-incrimination. So it depends upon the crime being charged. So if the crime charge is not does not involve the genuineness, or it does not involve falsification of signature, or if your signature will not be used as an element for the offense, then the right against self-incrimination may not be invoked. No? An example is the case of Marcelo versus Sandigan Bayan. So, here the petitioner's counsel argued that the signing of petitioner's and his co-accused name was not a mere mechanical act, but one which required the use of intelligence and therefore constitutes self-incrimination, presumably having in mind, said the court, the ruling in Beltran versus Samson, to the effect that the prohibition against compelling a man to be a witness against himself extends to any attempt to compel the accused to furnish a specimen of his handwriting for the purpose of comparing it with the handwriting in a document in a prosecution for falsification. But the Supreme Court held here that here in Marcelo versus Sandigan Bayan, the purpose was not to compare the signature of the petitioner for the prosecution of falsification, but merely to authenticate the envelopes as the ones seized from him and not to produce a non-existent evidence. Okay, so the Supreme Court held here that the requirement of giving a specimen signature did not violate the right against self-incrimination, because the requirement was not for the purpose of proving a falsification case, but for the purpose of merely authenticating the envelopes taken from the accused. If in order to prove that these envelopes were really taken from the accused. So proceedings where the privilege may be asserted, so that this right may be asserted in any proceeding, civil or criminal, administrative or judicial, investigatory or adjudicatory. And it protects against any disclosures that the witness reasonably believes could be used in a criminal prosecution or could lead to other evidence that might be used. Okay, waiver. So take note that the same with the other rights of the accused, this right against self-incrimination can also be waived. An example is if the accused will testify, will take the witness stand. So he may be he is now open for cross-examination. But take note that the limitation is that the questions must be related only or must cover only those questions in the direct examination. But still, he is open for cross-examination. So meaning to say, the accused waives his right if he takes the witness stand. Immunity from prosecution. So take note that if a witness is immune from prosecution, it's either he was given the transactional immunity or the use and derivative use immunity. There is a condition in exchange that the witness should tell everything he knows, He should reveal everything. So meaning to say, the privilege against self-incrimination is not applicable if the witness has an immunity from prosecution. Kasi the condition attached to that is that the witness should tell the truth, everything, including those statements that could incriminate him. Okay? So by the way, what is transactional immunity? Actually, this is a blanket immunity. It means that once the immunity is transactional, the witness can no longer be prosecuted for any offenses related to the to his or her testimony. So say for example, the witness has testified to a fact that is not yet subjected in the criminal case. So any future prosecutions cannot be allowed or is not allowed, Kasi nga, the immunity is transactional, which is total or blanket, But when you say use and derivative use immunity, it prevents the prosecution only from using the witness' own testimony or any evidence derived from the testimony against the witness. However, should the prosecutor later on acquire evidence of a crime committed by the witness, independently of the witness's testimony, the witness may then be prosecuted for the crime. Okay? So hindi siya blanket or total immunity. But then again, what is important here is that the witness, if cannot invoke his or her right against self-incrimination if he is enjoying immunity from prosecution. So speaking of immunity, we also have immunity statutes, no, exempting certain persons from prosecution. One example is under Section 3 of Article 16 of the Constitution, which provides that the state may not be sued without its consent. Okay. Another one is under Article 6 of Section 11 of the Constitution, which grants parliamentary immunities to senators or members of the House of Representatives. We also have under Section 18, Paragraph 8 of Article 18, or 13 rather, of the Constitution, one of the powers and functions of the Commission on Human Rights is to grant immunity from prosecution to any person whose testimony or whose possession of documents or other evidence is necessary or convenient to determine the truth in any investigation. We also have Section 17 of the Ombudsman Act of 1989, which provides for immunity under such terms and conditions as it may determine, taking into account the pertinent provisions of the rules of court. The Ombudsman may grant immunity from criminal prosecution to any person whose testimony or whose possession and production of documents or other evidence may be necessary to determine the truth in any hearing. So, pwede. Also, Section 5, Executive Order Number 14 as amended, grants the Presidential Commission on Good Governance the authority to grant immunity to informants or witnesses. We also have PD 749, which provides immunity from prosecution for any person who voluntarily gives information about any violation of Articles 210, 211, 212 of the Revised Penal Code or Republic Act 3019 as amended, Section 345 of the Internal Revenue Code, and Section 3604 of the Tariff and Customs Code, but subject to certain conditions. And also under Republic Act number 6981, the Witness Protection, Security and Benefit Act provides in Section 12 thereof effect of admission of a state witness into the program. Meaning to say, if a person is admitted as a state witness, then that person will be immune from criminal prosecution for the offense or offenses in which his testimony will be given or used, and all rights and benefits provided under Section 8 thereof. Okay? So remember those immunity statutes. Right of the accused to defend himself, right to be present at trial, right to be heard. So actually, the accused can defend his own self, no? Without the assistance of counsel. But take note that the court should determine, no, that the accused could properly protect himself without counsel. Otherwise, the court shall appoint a counsel de officio. So the accused can defend himself or by counsel. So he can hire his own counsel or a counsel of his own choice. He also has the right to be present at trial, not to attend the trial of his case. So he cannot be prevented from entering the court in order to witness, no, the proceedings of his criminal case, and the right to be heard. But then again, this right of the accused not to be defended or to be present or to be heard may also be waived if the accused will not appear in the trial of his case despite due notice, no, and without a justifiable reason, or if the accused will escape, who is escape bail, no? So therefore, he deemed to have waived his right, no, to be present, so that the case will proceed despite his absence. Right to testify as a witness. Ito. Again, the accused can refuse, no, to testify as a witness in his own behalf, or he may not testify, no, he may not testify, and as a result, he cannot be compelled to testify against himself also, di ba? But once the accused will testify as a witness in his own behalf, he has deemed to have waived his right against self-incrimination. Kasi he will open himself, no, to cross-examination. But again, merong limitation yung cross-examination. It will only involve matters covered by the direct examination. So, the defense counsel may object, no, any questions that is not related to the direct examination. Right to confront and cross-examine witnesses against himself. So again, this is a fundamental right which is part of due process. And the accused here has the right to ask questions against the witnesses of the prosecution by conducting a cross-examination. So if, for example, the accused was not afforded the right to cross-examine the witness, then the accused can move to expunge the testimonies or the direct testimony or the direct examination. So yan yung effect if there is a deprivation of the right to confront and cross-examine witnesses against himself. But if, for example, the accused was afforded the right to cross-examine the witnesses of the prosecution and the accused failed to exercise such right, then the accused has waived, no, his right to cross-examine. Take note that this right does not apply in preliminary investigations. Because a preliminary investigation is not, hindi siya trial of the criminal case. It is not a regular trial. It is a mere inquiry into to determine whether or not there is probable cause, no, to hold the accused for trial. And therefore, the rules of court, the rules on cross-examination does not apply in preliminary investigations. And take note here that the prosecutor has the wide latitude of discretion in conducting preliminary investigation. And the only way to question the conduct of preliminary investigation is if there is a grave abuse of discretion amounting to lack or excess of jurisdiction. Again, the effect of deprivation of the right to confront and cross-examine the witness is that the accused is entitled to have the direct examination stricken from the record. Right to compulsory process. This means that the accused can secure the attendance of material witnesses by asking the court to issue subpoenas. It's either subpoena ad testificandum if that is a witness, and subpoena duces tecum if what is sought to be secured is an evidence or an object, okay, or documents that are material, no, to the defense. Right to appeal. So in all criminal prosecutions, the accused shall have the right to appeal in the manner prescribed by law. An appeal is an essential part of the judicial system, and trial courts have been advised by the court to proceed with caution so as not to deprive a party of the right to appeal. However, ano ang effect kapag nag-appeal ka ng criminal case, ng judgment of conviction? It will throw the whole case wide open for review, and the reviewing tribunal can correct errors or even reverse the trial court's decision on grounds other than those the parties raise as errors. So it will open the entire criminal case for review. So pwedeng the decision of the appellate court will be adverse to the accused or favorable to the accused. So the appellate court will review everything. But take note that the appellate court is not required to review the facts of the case. It will accord great respect to the findings of the trial court. But there are circumstances that could call the review that would call for the review of the factual circumstances of the case, no? But generally, again, the findings of the trial court to the credibility of the witness are normally respected and not disturbed on appeal, no? So sometimes what has been subjected of the appeal is the applicability of laws, no, over the facts of the case. Or there may be facts that may be submitted for review, but generally the appellate court will accord great respect to the findings of the trial court. Only under exceptional circumstances that the appellate court will review the findings of the trial court. So that ends our discussion for Rule 115 of the Rules of Court, or the rights of the accused in the criminal proceedings. Thank you for listening and see you next video.